I'm going to start sharing.
Cool. I'll see you in 11 minutes and 14 seconds.
Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner live with Kirk Pendergrass and Chris Hallett.
What's happening, guys?
Good evening, folks. We are ready to rock tonight. We have some serious stuff going on tonight. We are going to lay it out there. Jeff Sessions, the DOJ letter, and Chris Hallett's work. We're going to tie this all together and show you how to use this stuff. This is going to be a show you're not going to want to miss. This is some priceless education right here because the homework has been done. Okay. So it's time to implement this stuff. And like I've said before, this is a new era. Forget about anything that you've been through in court and all the battle scars you have. Okay. Forget about what you know, what you learned, what you haven't learned, and listen up because this is the rule of law and we're laying the smack down here. It's, again, priceless education because, again, the homework has been done and Chris has done an amazing job of finally taking a little more time and read through his paperwork. So Chris will be talking more specifically about that stuff, and then we've got it set up where Ted's going to be putting it on the screen here so you can see it. And I'm going to try and post links here to the stuff as well so that you can follow along if my laptop wants to function long enough to do this. So with that being said, I'm going to turn this over to Chris real quick while I keyboard jockey over here.
All right, guys. This is it's crunch time. It's go time. It's again another interesting week, another real busy Monday, as Mondays go in my world. But we without going into too many specifics, because, remember, part of this litigation is kind of ongoing. So it's going to be, kind of hit and miss what I can go over and what I can't. But, the long and the short of it is we've made, pretty good strides in showing the judges in the courts the benefit of what loss prevention is and what it does and its role in protecting the integrity of the court and the integrity of the Constitution, which is the thing that they always go back to when making a decision. So, going back to, basically my reasons, the preface of the report, which was, basically says, look, you guys drugged me into this thing. I didn't want to do this, but because you drugged me into it, here I am. So let's just, let's put this crap aside, figure out where the wheels came off of the wagon and get it done. And that's exactly what we're doing. So
you asked for it, you're going to get it.
Yeah. I didn't do this. I didn't ask for this, guys. These actors did, right? I mean, it is what it is. So, that's that. Let's just grin and bear it, and we'll get through it. So now the significance of what this is, I was going back through my records and, the initial case where I filed the first version of the report was back in August in Utah. And as it relates to my case, the actual report with stuff that related to it went before Congress on October 10th of this year. So when you think about it, you know, this was docketed before Congress on October 10th. Jeff Sessions' letter is dated November 16th. I don't know about you, but I don't believe in coincidences. So, because the subject of the report is all about their guidance documents. I call them policies and procedures outside of law. And so, you know, what you call it doesn't matter. You know, when it comes before the court's going to call them exactly what they are in the Constitution, which is bills of attainder. And that said, those are forbidden. So quit doing it. So he shut, you know, like Kirk said, you know, as of today, there is no more of this. You're done, right? Quit doing it. So
quit doing it.
Yeah.
And that was November 16th, 2017. The Jeff Sessions said this ends today, right now, not tomorrow, not 6 months from now when you get around to it. Today.
Right.
It is now December 11th. Okay. We're almost 30 days from the day that Jeff Sessions said this ends today. So this is one reason why we're here tonight, is we're going to put this out there, this education. This is straight from Jeff Sessions. So coupled with Chris Halleck's work and the DOJ letter, more specifically for like child support stuff, which I'm putting together a document that I will be uploading to Amber and Steven and Kirks Law Corner groups, because I can't upload it to the page. You can't upload files to pages. So you'll want to look for that document when I get it done. And it's going to be used for, you know, situations such as, oh, you haven't paid your child support, you're going to jail. This document will shut that down quicker than you can say emoluments violations.
Emoluments violations. It's over.
One in every crowd, right, Ted?
As soon as they're done, as soon as they're done reading this document, there will be no excuse to continue with their parliamentary practices. That again, Jeff Sessions just said no. This stuff comes to a stop now, today, November 2017. This practice has ended.
Right. So when we talk about calculations of child support as a whole, okay, there's a strict formula for that, okay, and because of these guidance documents, they just took that formula and ran it through the shredder. You know, that formula doesn't matter. One of the most significant ways we can see the evidence of them doing this is what they've been doing to veterans in taking their veterans benefits and attaching them for child support. Well, the Office of Veterans Affairs has come right out and said point blank, no, you're not going to do that. So the fact that they've been continuously doing it is one of those things that's under fire. So when we talk about examples of, you know, how this impacts pretty much everybody else, specifically veterans in that group, this is one way that this affects and helps veterans, is it says, you know, hey, no more of this. Okay, you want to talk about the benefits for veterans, you have to go to the go to the VA and talk to the Office of Veterans Affairs. You know, that's not open to interpretation, especially at any administrative court or any other administrative authority. or as my comparison was, Walmart corporate officers can't walk into Target and tell Target employees that they have to abide by Walmart policies. Ain't gonna happen. So, I mean, that's in essence what we've just effectively shut down. So,
and this is where the understanding needs to come in. The comprehension is that code statutes, rules, regulations, and policies don't apply to the people. They apply to the public servants. That's the way our form of government is designed, and that's the rule of law in the Constitution. Okay, so what's happened is, we the people, through the first branch of government, the legislative branch, create the agencies. Okay, and this is where I go back to Title 74, Section 201 of the Idaho Code, which says that the people of the state of Idaho do not yield their sovereignty to the agencies so created. So this is what we're talking about, these guidance documents, what Jeff Sessions is talking about, guidance documents. Those are the rules promulgated to run the agency, and it's supposed to apply to the agents of that agency. It is not supposed to be construed to be applied to the people. It is not law and has no force and effect of law. It's supposed to apply to the agents of the agency. And again, like, we'll go back to what Chris just said, McDonald's and their rules and policies cannot apply to Burger King or Wendy's or any other ones. They don't have the authority to tell them what to do, nor do they have the authority in their rules and policies to apply those to the customers, because they're serving the people. And that's what our elected officials and positions of public trust are. They are servants. They are to serve us, we the people. Preamble to the Constitution for the United States of America. We the people instituted government for the protection of our rights. That's what the common law. Not stare decisis, not case law. That's not common law. Those out there trying to tell you that that's the common law, I have American jurisprudence, and in this document that I'm preparing, it specifically says that bills of rights and all that good stuff, that's our property. We own that stuff. We have creator endowed rights. Okay, amongst those rights is life, liberty, and the pursuit of happiness. That's not all of our rights. That's what James Madison talks about when they were talking and deliberating about having a Bill of Rights with the Constitution, when they were drafting the Constitution. There's a plethora of rights out there. There's no way to write every single one of them down in a Bill of Rights. And so in reading constitutional law and American jurisprudence, all bills of rights, because that's what it says, bills of rights, that's plural, more than one. So to give an example, Idaho Constitution, Article 1, that's actually a Bill of Rights. Okay, your state constitutions all have bills of rights, and it's usually the very first one. And it's state of Idaho, right here, Declaration of Rights. There it is. Declaration of Rights. This is a Bill of Rights for the state of Idaho. And guess what? Article 4, Section 1 of the Constitution for the United States of America says all of these are good in every single state. So again, going back to James Madison saying that there was, a plethora of these rights out there, there's no way that we could possibly write them down in one document. So there it is, folks. And let me tell you, in doing my research, I'm so overwhelmed with this one website that I found. So many documents, and a lot of those documents that are on there are actually in my Annals of America, a 21 volume set books, which one of them happens to sit right here and I've read from. This one's volume 2, which I'm missing volume 1, but this is Annals of America. And in there, some of this stuff is in these books, but there's some stuff I have found that's missing. Imagine that. But it's amazing what's out there to read, and it is seriously overwhelming to read this stuff, or even just look at it and go, oh man, there is so much stuff. So when I talk about we have 572 years of law that has been laid down, ordained, and established prior to the Constitution, what I'm talking about is all these documents, all these bills of rights, all these declarations from clear back from 1215 to 1787. That's the 572 years of law that I'm talking about. okay, the common law. All of that stuff belongs to us as property. And we, the people, knowing that these are our property, fundamental rights, whether they're either creator endowed rights or civil rights, natural rights. Okay, you have natural rights and you have civil rights. Creator endowed rights are the natural rights, fundamental rights. Okay, all those bills of rights, all those declarations, those are ours. They belong to us. And then that's why the Declaration of Independence says that we institute government. Okay, same thing with the preamble of the Constitution. We're instituting government. We, the people, say what the law says. They're actually not even at liberty to interpret the law. And that's right. The major misconception out there, is that the judicial branch has the power to interpret, and that is absolutely false. Okay, this is our property. We say what it says because we wrote it down, or our previous generations of we, the people, have documented it and written it down and put their names to it. And that's what a declaration is. We're declaring these are our rights. These are our property. So all these bills of rights in every state constitution, everything, that's all usable in any court, okay, at any time, because it belongs to us. So, yeah, it's a lot to take in.
Well, getting back onto topic, one of the things that is that I had used as a basis in writing my report was an initial letter put forth by the previous administration, March 14th of 2016, where they had laid forth 7 criteria of things that judicial actors, that's what they called it, judicial actors and private contractors, things that they could not do. Okay, so going back to
the Sessions letter.
No, I'm going back to the original 9-page DOJ letter from March of last year.
Okay,
I'm going back a little bit. So on page 2 of that 9-page letter, there are 7 things that they can't do, but they've been doing them. Right. Number 1, courts must not incarcerate a person for non-payment of fines or fees without first conducting an indigency determination and establishing that failure to pay was willful. Why is that important? And the importance beyond that is, for example, those of you who have been hit by a silver bullet, which impugns your ability to work, okay, you're paying that right there by simply articulating that fact, okay, that means your inability to pay was not willful. That was forced upon you by the actions of another person. Okay. So
unlawfully.
Correct. So you can shut them down with item number 1, but there are 6 more.
Yeah.
Courts must consider alternatives to incarceration for indigent defendants unable to pay fines and fees. So if you were hit by a silver bullet and you can't pay, but they want to punish you anyway, they have to consider other alternatives. Go cut grass for, on the highway crew, pick up trash, or whatever. But some other kind of community service, go work in the food kitchens or whatever. Work in a church. Item number 3, courts must not condition access to a judicial hearing on the prepayment of fines and fees. So in other words, if you have an outstanding bill, fine or fee, whatever, they cannot condition your access to justice, your access to a court, by saying, well, we'll let you in if you pay this fee first. They can't do that. And believe it or not, they were doing it. Courts must provide meaningful notice and, in appropriate cases, counsel when enforcing fines and fees. So in other words, that goes back to where we go from civil to criminal. Right. If they're going to think that they're going to try to incarcerate you or punish you or penalize you, you are entitled to counsel. That's Miranda versus Arizona. Okay.
That's also the 6th Amendment.
Correct. It is also the 6th Amendment, but we've already had that.
All criminal proceedings, you have the right to assistance of counsel of your choice.
Correct.
It doesn't say you have the right to assistance of a bar attorney, it says you have the right to assistance.
Right. And in number 4, it says that counsel. It doesn't say an attorney. It says counsel. Okay. So know the difference between the terms.
Yep.
Number 5, courts must not use arrest warrants or license suspensions as a means of coercing the payment of court debt when individuals have not been afforded constitutionally adequate procedural protections. There's a big one. So if they take your driver's license away without first charging you with a crime and convicting you of a crime before a jury of your peers, guess what they did? They just created a trespass of law, which is a cause of action. 42 U.S.C. subsection 1983, right? You took my my license away from me, whether it's a driver's license or a license to practice, whatever, okay? But you didn't give me my constitutionally adequate procedural protections first. Guess what? I'm suing you for that. And you can do that. Item number 5 tells you can do that. Number 6, courts must not employ bail bond practices that cause indigent defendants to remain incarcerated solely because they cannot afford to pay for their release. Okay? So in other words, they can't say, okay, well, guess what? You're stuck here now and you're not getting out until you pay this fine or fee. How many times have they done that to how many people out there? Item number 6 says, no. So basically, they don't have the right to put you in there to begin with, but even if you are in there, this is something they can't do to keep you in there. So
Right.
Item number 7, which is my personal favorite, courts must safeguard against unconstitutional practices by court staff and private contractors. Okay. Court staff, meaning anybody in the court. Could be the judge, could be the clerk, could be the bailiff, whoever. Okay. Private contractors, private prisons. There's a perfect example. Okay.
Right.
So if the private prison's policy is to not let you out until you pay this fine and fee, that's an improper use of a guidance document, right?
Yes, it is.
So you see the significance of these, there's actually 3 documents because this letter does have a cover letter that goes with it. And the 9 pages of the outlining the 7 criteria I just read to you go into specific detail. They outline specific cases that the DOJ studied when creating each one of these criteria. Okay. The Ferguson incident is in this report. Okay. This document filed by the DOJ. So that's one example. And when it comes to where the second letter came from probably more because my work was primarily based on that letter. Item number 7, right? Unconstitutional practices, right? Well, that's where we went a step further and said, look, they're doing it anyway. And, here's why they're doing it. They're doing it based on these guidance documents, these policies and procedures. I'll read it verbatim the way I wrote it in the report. It is actually
what page? Which one? What page?
The page 3 where the negative nexus starts.
Okay. Let me see.
Not the Roman numeral 3, the actual page number 3.
All right. I'm on it.
We're going to paragraph number 6, page 3.
Almost there. 1, 2.
Okay.
So 2. Wait, 3 negative nexus. Okay. Paragraph
There it is.
6.
Now, if you read the transcript where Jeff Sessions was speaking, when he was explaining his letter to Congress, you're going to notice some parallels between what he said and what I said right here. These rules and policies are clearly exploited for the financial gains of the practitioners operating within these proceedings. The U.S. Code calls them unjust enrichments. Black's Law calls them fruits of a crime. The Constitution calls them emoluments. These emoluments are clearly designed to provide motivating factors to ensure the practitioner compliance while ensuring their silence, or even motivating them to commit perjury, which taints the entire proceeding as poison fruit. So when you start to hear fruit of the poisonous tree or poison fruit, that's probably where that came from. And basically, I finished off with referenced in the aforementioned, clearly defined within the preferred Black's Law text of this court as follows. And I gave, at that point, the list of definable things that are defined in Black's Law and how they can use those definitions in assisting them to define what is a bad emolument and what is a good emolument. Okay? As it relates to the practice of law, not the court, not the judge, not anybody else. We're talking about the guys who prepare the documents, walk in the courtroom and say, blah, 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 blah. So if you hire somebody and you're paying them to act on your behalf in good faith and they don't do it, well, there is remedy in law, in federal law for that, but it's not defined in most states as defined in the practice of law is concerned. Now, in my practice, that's a different animal. My practice actually does define it.
Not trying to take you off track here, so just remember where you're at here. But where in the Constitution did it say? I know that it says that there shall be no imprisonment for debt except for fraud.
Hit him, Kirk. Get him again, baby. Get him again.
But I mean that, and see, actually, the reason why I'm actually fully aware of this particular part, because we had a lawsuit against Ada County Courthouse or Ada County Jail, Webb versus Ada County back in 1995. And I happened to be incarcerated at the time. And I got a hold of this partial consent decree. And part of it was, it's unconstitutional to incarcerate people for debt, for failure to pay fines, blah, 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 amongst other unconstitutional jail conditions. And man, did I have them hopping around that jail, and we played the game. We went from being in the dorm and in the basically best living conditions you could have in that jail, to throwing me basically into the hole and then into a closed custody unit, deprived of most of every fundamental whatever liberties and privileges you have when you're incarcerated, all because I started, enforcing and making claims on this partial consent decree. And so I just stuck to my guns. And when I was in the closed custody units, I'm like, well, you can't house me in this unit. This is an unconstitutional jail condition. See it right here? This sink is plugged, or this drain is plugged, or this shower is disgusting, or, it was pretty gross stuff going on there. After about the third time they had to move me, they're like, well, what do you want from us? So anyway, I'm like, well, put me back in the dorm where I was at before you decided to mess with me. Or, I'm not going to stop doing what I'm doing, but I'm like, this is basically fruits of, well, not fruits. This is basically proof that you are, messing with me because I'm trying to uphold the law here. I'm trying to hold you accountable. And now you're trying to punish me for that. And that's unlawful. And then I get a guy out of jail because he come into jail for failure to pay fines. And I'm like, you can't do that. So the first guy I get out of there, the officer that was up there at the desk, he was pretty cool about it. And I showed him the partial consent decree. I read it to him. And he's like, well, you're absolutely right, and pulls up his case file and, the records. And yeah, by all means, he's in here for failure to pay a fine, and that's it. So he called the sergeant down there, and, the officer and the sergeant were out there behind the glass in the hallway there. And we could see him, we couldn't hear him, but they're sitting there talking to each other and looking at this partial consent decree. And next thing I knew, the sergeant gives the jerk, you know, get him out of here. Comes back and he's like, roll your stuff up. You're out of here. So, yeah, you know, some things can be done just by simply grabbing the paperwork and going, hey, you're in violation of the law here.
Was that a private facility, Kirk, or was that a public facility? Do you remember?
Oh, that's public. It's Ada County Jail.
Okay. I was curious because I was wondering how that relates to the DOJ letter.
Well, this was back in 1995.
Ah, okay.
So, you know, and then the second guy I got out for the same thing. I overheard him talking, well, I'm in here because I didn't pay my fines. I couldn't afford to pay them. So, you know, they just threw me in jail. I have to do jail time. And I'm like, no, you don't. That's unlawful. And so, you know, the second one I brought up there and kind of had a round around with that officer because it was a different officer. And I said, look, you can either do your job and get this guy out of here, or I can walk right over here on that phone, get on that phone, and we'll just start a federal lawsuit right now. And that officer looked at me like I was crazy. And I said, well, what's it going to be? Are you going to do your job, or am I going to get on that phone? He's like, well, let me talk to the duty sergeant, you know. I said, okay. Sure enough, he called up the sergeant. And apparently I'd made enough ruckus in the jail that they knew exactly what that officer was talking about as soon as he told them something about a partial consent decree. And this kid was in here for failure to pay fines, and it was unlawful. It wasn't but 2 minutes after he hung up that phone, the sergeant was down there telling him to roll his stuff up. You're out of here.
So, it's amazing when you actually walk up, and there's two ways to do this. Okay. Like in your case, you did what I did. I walked into Utah and basically said, I'm bearing witness to this, and I'm prepared to go before a jury and say that I'm bearing witness to this. Mm-hmm. Well, by the way, here's my credentials that say I'm an expert. So, yeah, it adds a little something, a little bit of extra something to the effect, because again, when we talk about stuff that we're working on, this is stuff that the courts, these are advantages the court's never seen before, right? They've been kind of lounging around, you know, doing the same crap they've been doing since 1700s. Oh, you know, same shit, different day, blah, 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 blah. Well, guess what? We're showing them, not only can we do this better and cleaner, we can do it in accordance with what the law says, because here's what the law says. Oh, you're asking that question? Well, let's see. Somebody wrote a report on that. Oh, I got a report. I got a law journal. I got a case. I got, you know. So based on all of that stuff, same situation here, blah, 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 blah. The court said in a limited government, because that's their favorite. That's what they start with, in a limited government, what you can't do. So,
yeah, I mean, Article 1, Section 9 of the Constitution for the United States of America says powers denied Congress.
Right. Yeah, denied. There's a key word.
I mean, you're flat out denied right here. And this is part of what we're talking about here with these guidance documents, the bills of attainers in Article 1, Section 9 and 10.
Right.
It is denied both to the federal and to the states, because Section 10 says powers denied to the states.
Right.
I mean, that's a straight up denial of power. There is no delegation of authority here. And that's where we go to the 10th Amendment. The powers not delegated here are reserved to the states or to the people. Okay. Obviously, we reserve to ourselves creator endowed rights and all of our bills of rights and all of the declarations. We did not give them any power over that. And with Section 10, powers denied to the states, I mean, that's a pretty bold-faced statement, denied to the states. So you're not allowed to, no state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, imagine that, make anything but gold and silver coin a tender in payment of debts. Imagine that. Pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. That is a powers denied to the states. Number 2,
Right.
no state shall, without the consent of Congress, lay any impost or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws. The net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to revision and control of the Congress, us, we the people. Number 3, no state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage foreign power. Bar attorneys, or engage in war unless actually invaded, or in such imminent danger as will not admit of delay.
Where do you guys keep your ships in Idaho, there, Kirk?
Well, you know, they raised the sea level
Right.
back in 1845 to about 20,000 feet.
On the side of Mount what? You know.
Yeah.
Oh God, that knowing you're in Idaho, that just cracked me up.
Yeah, you know, I'm at like about 2,800 feet above sea level here.
Right.
You get up here just 45 minutes away and you're at 6,000 feet.
Right. So, you know, it's funny because when you talk about, you know, positions of public trust, okay, basically meaning we've hired them.
Mm-hmm.
You have one job, do this job, and you get paid to do this job, right?
Right.
And the thing that sucks is for, you know, all these years, we've only ever hired one entity to do that. Well, is it any wonder the poor bastards in the court, the judges, have gotten really crappy work, right? I mean, they're going off of one set of rules. One, you know, they got one entity to choose from.
Yeah.
I got some news for them. Other fields of practice do this all day, every day, and we do it better and cleaner than any lawyer ever could.
Attorney.
Or attorney, whatever. You know, I mean, let's call that spade a spade. There aren't lawyers anymore. Well, barring yours truly, but you know, they're attorneys now. They take your stuff and give it to somebody else. That's their job.
That is their job as an officer of the court. Their first line of allegiance is to the courts and then to the public, not to you.
Right.
And the root word of attorney is to torn.
Right.
They should take your property and give it to somebody else. Property being rights. Your rights are your property.
Mm-hmm. And they do this and they don't tell you they're doing it. Well, guess what? That's a fraud. Right.
That's an unjust enrichment.
Yeah. Because if you'd have told me you were taking my property and giving it to somebody else, I would have said, oh, hell no, you're not. I'll do this myself.
Yeah. We're under the presumption that when we hire an attorney and we give them that $2,500 retainer, that we're retaining them to defend us.
Right.
And our rights and protect us, but they don't.
Right.
That's
so when
not
you
what
talk
that
about
does.
where the breach of trust comes in, that's where the breach comes in. Right. It's that simple.
I mean, we can we smack the bar with Title 15, Section 1? That's $100 million lawsuit.
Well, we can smack them with whatever we want. I mean, it just depends on what the
it's $100 million fine for the agency, which
right.
to act outside it, or corporation, because that's what the bar is a private corporation.
Correct.
Being allowed to operate within a state.
Right.
Because it's always the Idaho State Bar or Oregon State Bar or Wisconsin State Bar or Kentucky State Bar. It's all a private corporation, but they give you it appears that the Idaho State Bar is actually an agency under the state of Idaho, the people of the state of Idaho.
Right.
And
that's not it. Yeah, it's not it. They get a private contract that they have to renew.
Mm-hmm.
Right.
Every year.
Yeah. And because it's like, well, they're the only ones who've ever laid claim to that contract until I said, hey, wait a minute, I want to bid on that contract.
Well, the thing is we the people don't have the power to delegate the power to contract that way.
Correct. But I said all things being equal.
It has to be an agency.
Right. I said all things being equal, I'll create this secondary private corporation, and we're going to call that loss prevention. And I'm going to show you what loss prevention is, right? In context of what the law says, right? Because I can do that. That's a right claimed by me, protected under the 9th Amendment. I'm claiming the right to do that. And there's nobody can argue it because that's my right. It's my property. So I'm claiming my right, and I'm claiming my ability to do it. And I put my name on it with those credentials that are, you can go to any agency or go to the state and look them up, and you can find out, yes, I'm licensed. Yes, I'm bonded. Here it is. Okay. Can't do that with a bar card. Hell,
But I mean,
I actually jokingly at one point said,
more here.
what's that?
It said, we go through your paperwork here some more. You don't have to have a license to practice law.
Correct. But I'm taking my license and I'm applying it. And I'm showing, you want to know what good faith in trust practice looks like? I'm going to show you what good faith practice looks like. Okay. Position of trust, because I'm licensed to do that by the state.
Technically, and I've gone through some of that stuff, it's for profit. Okay.
Right.
So if I wanted to go in and be assistance of counsel to another man because I want to protect his rights, and he doesn't really understand how to do that because he hasn't educated himself. Okay. I have the right to go in and defend him. Okay. As long as I'm doing it for profit.
17.
What's that?
Federal Rule 17 in civil, and don't ask me to remember the criminal off the top of my head.
Right. So regardless, it has to be for profit. So that's why the bar is the way that they are, and that's the reason why Chris is doing his E-Clause Corporation, registered trademark. Okay, that's his corporation. Chris Hallett is the head executor of E-Clause. That is loss prevention, equal protection of the law, to ensure equal protection of the law.
Right.
Make damn sure your rights are protected. So with what's in his paperwork, which we'll see here in a minute, is that it has to be for profit in order to have some sort of license to do that.
Right.
As an occupation. But Hale versus Hinkle actually limits all that. If you're not going to do it for profit, okay, we have a private contract here, which has nothing to do with the court, doesn't have anything to do with the state, for me to go in and perform my fiduciary duty, which I don't need a business license for, because I'm not in business to do this. I'm not doing this for profit, not a gain. While I do have the right to be compensated for my time, I have the right to contract my labor as I see fit. That's a right. So we can't convert any of those rights into privileges, license it, and attach a fee to it. And where everybody has under the 6th Amendment the right to assistance of counsel in criminal, we have the right to assistance of counsel everywhere we go at any time. We don't have to be in court. So if you're ever, have somebody says, "Well, I want to talk to you," well, let me have my assistance of counsel present. Well, this isn't court. We're not in a criminal court. I don't care where we're at. I have the right to my assistance of counsel.
Right. Are you detaining me? Are you placing me under a condition of arrest?
Right.
Because if you're detaining me, I have the right to counsel. Period.
That's right. For any time, any questioning at all. And that would be a deprivation of your right of liberty. Again, that's in violation of the law.
You'd think that these things have
authority in costume, which is in Title 18, Section 242, is in costume. Okay?
Right. So, ironically, these things that we, myself, I have just taken for granted. This is stuff that I know. I learned, back in, school and college years ago. so many people don't know and understand the complexities of what this stuff is and how it works. And the further I got into this, I said, you know what, there's a need for this. And if there's a need for it, that means I have a duty to do it.
I was going to say duty.
Yep. And
that duty is,
honest with you, I don't like this any more than anybody else does. If I had my druthers, I'd still be sitting in my office writing reconciliation reports for end of year for the corporations that I have worked for. But because of the crap that they've pulled on me, now I got to do that job. Okay. And show it to the benefit of the court, the same way I show that benefit to the CEO of the corporations that I worked for, and protect the integrity of their corporation and their profits for their shareholders, blah, 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 blah. So drawing that parallel line, right? This is why attorneys don't like me very much, because I'm showing that taking somebody else's stuff, right, and giving it to this guy, well, that's not what the law says. This guy was brought into this thinking he had somebody that was there to represent his interest, and now come to find out that's not what's happening. Well, you know what? I have a problem with that. That negatively affects the integrity of this court, and it affects the court. Negatively affects this court's ability to do its job in law, and it impugns the document that this court was assigned to protect, that being the Constitution. So let's
be the supreme law of the land. You think you're
exactly
the supreme law of the land, or what?
That's right. So I said, okay, let's take this from a different level. Let's take this example, and we're going to break this sucker down, and we're going to find out what's true, what's not true, and we're going to make the determinations of what's an emolument based on this limited scope of actors right here, right? Let's take just this small little piece and break it apart and do what we do, which is find out where the loss happened, right? And how great was that loss? We got to measure it and figure out what we're going to do to correct it and make this person whole again. Well, that's actually what's going on in my Utah case. They're breaking it down. They're finding out as the longer this goes, the loss is continuing, right? So when we talk about compounding interest, I don't know if you know how to calculate that. This is basically the loss is compounding the same way interest compounds, and the bill gets not only steadily increases, the amount of damages increases exponentially based on the amount of time, okay? And the damages accruing, that's where the compounding comes in, right? So, you know, what started out with something so small has grown into something so ridiculously huge based on such a small original transaction, occurrence, or event, right? And where do we stop the bleeding? Well, that's what we've asked the court to do. And they've never been asked that question before. So, you know, we said, okay, let's ask the question and see what the court says about it. And they're doing it.
Right.
So,
yeah, I mean, how is the attitude up there with those judges and stuff? I mean, just to kind of give people an idea of how you're being treated.
Well, I'm going to be honest with you. It's in the beginning, it was the same as everybody else. Okay. You know, well, that's not how we do it here, right? How many times have you ever heard that? You walk in there and say, well, that's not how we do it here. Well, if you're going to claim a position of authority over me, you're going to do it the way this thing says it, this Constitution says it, because that's what the law says. So we actually had to go through and have this monopoly argument first. And they said, which is part of my report, and, you know, you can read that. I mean, the case was full of errors. It was a train wreck. I mean, and I called it that, and the judges agreed with that. Yes, it is a train wreck. So the only way to prove that something was broken was to walk in and break it right in front of them.
Yeah.
Yeah, so that's exactly what I did. I walked in and showed them that it was broken. So I said, okay, now that we've established that it's broken, guess what? I don't want to fight with you either. Again, the non-programmed response. They're expecting me to walk in there and, you mother, blah, 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 right? Because that's what they do to us all the time. Well, that's not what I did. I walked in and said, okay, well, all right. Now that we've established it, good. Now let's get down to fixing it, because that's what we do here. There are no problems. There are only solutions. Let's find a solution, because that's the thing I like to do. I like to find out where not just what's broken, but what's it going to take to fix it. That's I get my little briefcase out and put my little algorithms together and do the stuff that I do and say, okay, how are we going to figure out how it broke? All right, what's the trouble code? How do we troubleshoot this sucker?
Right. Yeah. What's the code that's being broken here?
Right. How do we figure out how to troubleshoot this bastard? Well, that tool wasn't written yet. I called it the negative nexus. I found the items that were in law and I built this little equation, this little mini algorithm, and said, okay, we can use this, right? It's not perfect, but it's right. It's based in law. Okay. It says so in the book. So we'll take what's written in the book and we're going to apply it just for the fun of it. And we did that.
The negative nexus. That's
negative nexus, right? We took the negative nexus and we applied it in a couple of cases and showed the court that what it has been accepting as good in good faith since the 1700s is not good faith. It's fraught with errors. It's fraught with violations. I mean, all over the place. So now all of these things are in plain view of the court. Something that's never happened in the history of our country. Why? What was that? Was it you? Wasn't me. Are you there? It says my mic is muted. Or your mic is muted. Somebody's mic is muted. Can you hear me?
Yeah, I got some background noise here. I should mute.
Ah, okay. Well, anyway, we were talking about it, and it was just like, okay, well, now that you guys see what we see, okay, the negative nexus, I'm going to show you what the parties see. This is not the stuff that the court normally sees, because you've only had access to one point of view on that. So let's show you from a different perspective how this works. Oh, by the way, when you take what this particular person wrote for this client and you compare it to what he wrote for himself, you can see a major difference. The thing he wrote for the client looks like something that a kindergartner would have written by comparison to what he wrote for himself. So that became plain view of the court. Again, something that's never happened in the history of the country. So now that we've shown the court again what's broken, okay, how do we equate that to equal protections of my client? Well, the answer is we go back to the beginning, right? Well, to do what this person did, that's a fraud upon the court, is it not? Well, yeah, technically speaking, it is. So that being said, we go all the way back to the beginning and we literally have to wipe that slate clean, right? Terminate that case. It's poison fruit. And that's exactly what the judges want to do anyway. Figure out a way to kill a bad case. That's one of the things we hire them to do. So here's the problem. How many of these cases are there?
So can you actually go back and go over your negative nexus there so people can actually understand how that works or attempt to understand how that works?
Absolutely.
You had it right. You had it right there, Ted. Go back up.
I am going to pull up in my
Well, no.
Because I wrote this actually out in my indictment. So
yeah, well, Ted just had it pulled up here on the screen so that everybody else could see it.
It's back. It's back now.
Okay.
Right there. Yeah.
I'm going to pull up something here real quick because
it's on page 3
there.
Because this is amazing right here, using math to apply math to your situation, to your case, and how when one right is deprived, that puts a negative over here on you, or a negative on them, because they're not supposed to be doing that.
Correct.
So mathematically, this is a mathematical equation, how to work out your case in a manner that shows them mathematically how you've been screwed. And this isn't justice, because justice is about balance.
Correct.
So I really want Chris to explain this, and this is his work. This is what he does. So this is awesome stuff right here. So pay attention.
So when we create the negative nexus, okay, when you hear me say it's based in law, okay, look right underneath the title. You're going to see 2 maxims of law there. You got your book open, Kirk? Your maxims of law to interpret those for everybody? You muted your mic again, bro.
Yes.
Okay.
Legal maxims. Which one?
Let's see here. You're looking at it. First one, negatio destruit.
I can't see which one it is.
Okay.
I think Ted needs to scroll up just a little bit to get into the negative nexus part. It's like right at the top of it. Scroll up a little bit, Ted.
Okay. Look at my look at the camera so it's in real time. That's the negative nexus right here. I'm on page 3. Now I'm at the very top of page 3. You want me to go to page 2?
Okay. While these guys get caught up, I'll go ahead and run you down through these briefly.
There's
the first maxim of law that I applied: a negative destroys a negative, and both make an affirmative. Okay, those are basic mathematical principles of algebra. Okay, so basic mathematical principles of algebra are accepted in law. There's even a legal maxim on it, and that is the legal maxim. The second legal maxim is a double negative is an affirmative. So basically, we've got 2 maxims of law that say pretty much the same thing.
What page are you on now, Chris?
I'm in the Black's Law book on page 1935 on the 10th or 10th edition.
I don't have Black's Law book up. I have.
Okay.
I do. I have my 9th edition here.
I'm going over the 2 maxims of law right underneath the title of the negative nexus and basically why those are there.
Okay. I have, just so you know, I have Sessions letter. I have the Dear Colleague letter, which you read earlier. Your short version and your long version. Okay.
Right now, we're just looking at the negative nexus itself. Okay. From the negative nexus right down to the line underneath it that says, you know, what the parties see and what the court sees. Okay. So when we talk about how do we base this equation in law? And the answer is it's based on these 2 maxims of law, okay, which are ways that we can apply the law, right? So when we want to apply the law, we need scientific principles and practices to do that, right? Because law is the science of what is good and just. So that said, that's where we base the scientific principles of algebra. The second one, where we talk about Article 4, Section 4, mandatory reporter, 29 U.S.C. subsection 1109, that's mandatory reporting, okay? An agent of trust has to report any bad action, right? Whether it be against you, whether it be against the children, whatever it is. They have a duty to report those actions. What they do is they selectively report, right? They decide, as the lawyers, they don't take the totality of it and report the totality. They selectively decide, hey, what am I going to tell the judge and what am I not going to tell the judge? Okay. The problem with that is because this attorney took your rights and said, I'm giving them to somebody else. This guy is the one speaking on your behalf, not you. So, for example, if you have a report that confirms no abuse or neglect in your family law case, and the attorney is purposefully withholding that, that's exculpatory evidence. This is going on all over the country. Well, because that's a violation of Article 4, Section 4 of the Constitution and 29 U.S.C. subsection 1109. That's the reason that I put those two together. That's why I drew those lines between those two items. The next one, Article 1, Section 9, Clause 8, is they get paid to do it. And because they construct these cases the way they do, they're drawing this crap out, right? Why? Billable hours. So the longer they draw this out, the more money they make. Well, guess what? We got a law for that. 28 U.S.C. subsection 1927. Counsel's liability for excessive costs or vexatious litigation. So because that would constitute a bad emolument, right? Article 1, Section 9, Clause 8. That's why I drew those lines together. That's how those two items fit together. Okay? Now, when we go into how do we work the equation? Okay, how do we apply the equation? The first step is to identify each factor in context of its current practice or practices for closer examination. The first value of -1 is the evidence presented or exculpatory evidence intentionally obscured from the eyes of the court, under the premise of being used against the targeted parent in family court, or prosecutorial presumption of counsel unbeknownst to the court. As the court accepts these presentations in good faith, as it has since the 1700s. That's the monopoly, right? The multiplication sign establishes the elapsed time, meaning the first factor of -1 cannot change. It is now a mathematical constant in context from now on. In other words, you can't unring a bell, which is the branding that we were talking about. Remember we were talking about branding? Okay. Right. So they came out and made this ridiculous claim against you and withheld the exculpatory evidence. Well, you can't unring that bell, right? That's the silver bullet, right? That's what, myself personally, I've suffered from that. Now, the second factor of -1, this is where it gets a little tricky.
What number is that? 9?
Yeah, we're looking at the actual equation. -1 times -1 equals +1. Okay. I'm breaking down the equation by factors.
I see.
Okay. I didn't hear you, Ted. What was that?
We're good. I'm right back at 5 and 6.
Now, I wrote this. This is all actually, believe it or not, I'm reading this from my criminal indictment, which is going to be posted in the group, so you guys can take this stuff and download it and read it. So, basically, and this brings us to the second factor of -1. Okay, so we've got the first negative being used against you, the elapsed time, which means you can't unring the bell; it doesn't change. The second factor is the actions of the practitioner. Okay, now that second factor, that negative, not the one that you can't factor out a person. The person is a constant, but you can factor out his or her conduct. Okay,
the actions performed by the practitioner.
What was that, Kirk?
The actions performed by the practitioner, the one that's supposed to be defending you.
Correct. Now, because of my fiduciary license that I hold that's registered with the state, I can grade that conduct. I can say, hey, this is good conduct, this is bad conduct, right? And I can put my license number on it, which I've done. So I've said, look, you just factor out that bad conduct. Remember I said the comparison and contrast. Look what this actor did for the client, my client, and look what he did for himself. See the difference? Okay. That's applying it before the court. That's me using my credentials to demonstrate to the court, look, this is what he's capable of, and this is what he did. So you see how that negatively affects my client. So what we end up with is the court now says, that's me introducing a contrary positive. That's calculus. Okay. So we factor out just the negative sign, leaving this actor did it and it is what it is. But had he done what he should have been able to do, what he's capable of doing, right? Defending his client in a position of trust. What we can now see is -1 times +1, well, equals a -1. Now the court can see the negative, because now we can show the court that there is a negative there. Okay. The court can now act on that negative and make its determinations based on how many counts, how many times we have to do this, run these actions, these things that have already happened through this negative nexus to make my client whole again. And that's exactly what loss prevention does. So we had to literally build the tool, the scope, to figure out exactly the scale, exactly how many times these actors have done what they've done. And again, because it's never been done before, at least not to my knowledge, this had a pretty major effect on what was perceived as a hidden monopoly, right? That's where the swamp came in. So when I walked up and popped the cork and the emoluments clause and said, hey, what's this? They're going, put that back in. You can't pull that. So
I can't believe you brought that up. How dare you?
What do you mean it's in law?
You're supposed to do that.
Oh, you mean I just torn your shit and gave it back to the people?
You're messing with our profit.
Yeah. I just torn your stuff and gave it back to the people it belongs to? Oh, man. Well, that's your bad, not mine.
And there goes my phone.
Yeah, mine quit about 15, 20 minutes ago, so I can't see any comments right now. But I'll have to go back through them when I can get it working again.
I'm going to get this secondary camera set up so you can see the screen in real time. That way I can bring up the restream.
It is working on my computer. Amazing that my laptop is running this, especially with everything that I have open.
Yeah.
Hey, Ted, do me a favor and see if there's any questions that we want to address before we go any farther.
Yeah,
as far as how to work.
Let me see here. Let's see. Good job putting this together. Legal maxim. High French. We all need stress away. Agent of trust duty to report. Why the state refuses me a court of record. That's Brian Van Aken. Brenda, mathematical constant. And then Brenda, I got to get this Black Law book. Doctrine of...
We love you, Brenda.
I have Black's Law 6th edition and 9th edition. Chris has the 10th edition, but I also have 1st and 2nd edition, and 1st, 2nd, and 4th edition digitally, and I also have Beauvair's Law Dictionary from 1856 digitally. So
yeah, I've got 9th.
I tend to read
digitally here somewhere
on occasion.
Me, I'm old school. I like to pick up the book and look at it in the book because I can see, what's around. Not just that thing. I like to look at what's around it.
I learn
a lot about what's around it.
Your friend that comes on the trucker, he talks about Westlaw a lot. What is that?
Yes.
Something online you pay for? I'm assuming.
Yes. Westlaw is basically like an online law library.
That's cool.
Okay, they have just about everything you can frickin' think of law-wise on there. But again, I'll reiterate this. I've been down to my local law library, And I'm the type of guy that actually likes to open up the book. Call me crazy, but I actually like the smell of some of the older books when you open them up, and it's just like, you know, just that old smell is of a book. It's just.
I thought I was crazy because I'm that way too. I like to look at the book,
and I love reading it for myself out of the book in black and white, because I don't trust the internet. Okay, even though I'm sitting at the computer at the law library through Westlaw, I was looking up some American jurisprudence one time. And I'm like, okay, so what? This seems weird, you know? So I went to go grab the book that it says it's from. And I'm like, okay, I'm reading the book and I'm reading what's on the screen, and they're not the same at all. Right. Not even remotely close.
Right.
And I'm like, what the heck? So I went and got the law library clerk. And I said, can you come over and help me with this? Am I doing something wrong here? I mean, this is what it says on the screen. Do I have the wrong book? You know, I mean, I didn't try to blame anybody else but myself. So I need some help here, you know? What's going on? This is like racking my brain trying to figure out if I got the right thing here or what. And she looked at it. She looked at the book. You know, she looks at mine. Okay, yeah. She's like, okay, yeah. She's like, wait a minute. You're right. There's something wrong here. And so she looked at what I was looking at on the computer. And, you know, it breaks, Westlaw breaks stuff down depending on what you're looking at. And so I was looking at American jurisprudence. And, of course, I'm looking in the volume 16 constitutional law section. And actually, I can't remember if it was that particular section or not. I think I was looking up natural rights. And she went under, like, some of the subtopic headings. And she's like, okay, well, this is actually where it should be. And so we went back over to the books, and she's like, it should be in this book. And we pull it out. Sure enough, open it up. There it is. Exactly word for word what's on the screen. But what was on the screen was giving the wrong reference.
Right.
So, you know, I even mentioned to her, I'm like, maybe you might want to call Westlaw or whatever, because they're the ones that have responsible for putting this information out, and get that corrected. Because if somebody misquotes that and goes to court, and, well, this is what Westlaw says, and then a judge goes back into his back room and goes to grab that book to verify what you've put in your paperwork or what you're saying, and it's not in the book, there's going to be some problems because you just misquoted the law.
Right.
Or you're trying to use something that's not legitimate.
Correct.
So another reason why I like to go to the book and read it for myself right out of the book.
Right. Maybe we're just too old school, Kirk.
Yeah, right. I mean, don't get me wrong. I do a lot of reading of certain stuff online. Right. But don't trust. I mean, I don't want to say don't trust, but don't trust everything that you find online, even from semi-reliable sources, reputable sources like law.cornell.edu.
Right.
Even some of that stuff, I will go still to the law library, and I'll go to the U.S. court reports, and I'll pull up that book that has that U.S. court report in it, that case that I'm looking at, and I will read it for myself. And some funny things there too is sometimes some words are omitted. Sometimes a whole paragraph has been omitted. What's the word I'm looking for? Omitted. Pardon me.
Yeah.
Omitted. So it's when you're reading stuff online, and you got to think about who's putting that stuff out there for you. It can misguide you. There's some things that I've found that I'll go look up the case, and like, wait a minute, this is not even showing online. This paragraph's not even in there online.
Right.
It is in the book. So
going back to the book, ironically, and to finish off with how do we apply the negative nexus in law and what does it mean? Well, we can basically, we also know that anyone acting under the color of law cannot stand on good faith if they're trespassing against the law. That was decided in Owen versus City of Independence. Okay, right. Back from 1980.
That's the case that removes judicial immunity. All of it from any agent.
Right. Exactly. lawyers, judges, police officers, blah, blah, blah.
Yep.
And what law was broken, right, when they did this was, it goes back to the old Roman law. Lex scribionia is a law of the late Republic abolishing the acquisition of predial servitudes through prescription. Well, that's what guidance documents are. They establish predial servitudes through prescription. You go to work and work your ass off to pay this debt, or we're throwing you in jail. Right? That's what they're trying to pull. Well, that's not what the law says. The law says you're forbidden from doing that. Mm-hmm. I'm denying you from doing that. Right? So, you know, when you talk about not just defining the problem, you can give them the solution that also exists in law. Okay? And that's one of the things the judges want to see. They want to see not just how you know, on this date this happened and blah, 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 and you go into your whole soapbox of stuff. That's not what they want to see. They want to see what broke, okay? Where does it exist in law, okay? Is there a remedy in law for it? If so, what is it, okay? And, you know, show us all of this stuff. Don't just bring a problem to me. I want to see the problems. I want to see how you calculated the solution, and I want to see what the solution is. And I'll make my determinations based on that. Well, I did that and called it a report. So, in other words, I didn't ask the court to do anything. I said, oh, by the way, here's what's going on. I bear witness to this under my professional credentials, and here's how we fix it. And now I'm asking them to fix it for the first time ever. Again,
in the history of our law courts, the emoluments violations, this just one word out of the Constitution has never even been addressed.
Right, because you know it's been left to the U.S. Code, malfeasance of office, you know, extortion, embezzlement,
uphold their own law.
Right. So because it was never defined in constitutional law, it's been obscured from the federal courts for for how many years? 230 years. Well, we tied it into, by the way, this is a constitutional law. This was written in our founding documents, right? We have to apply it in context of a limited government. Why? Because government has gotten way out of hand. It's trespassing every single day. It's an epidemic, blah, 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 blah. And, you know, so that's why I'm doing what I'm doing.
That's, pretty amazing stuff out there, what you've written and what's being proposed to them to look at and review, which I'm so glad that they didn't just blow you off and treat you like dirt like the rest of us, because again, you know, back when we first started talking, I'm so glad that you have the credentials that you have, because if it was anyone else out here like me and Ted or Brenda, anybody else, you know, they would have just blown us off. But they can't necessarily blow you off because you do have a fiduciary license. And, oh my gosh, this guy actually is talking some common sense, and I understand what he's saying. We got to take a look at this.
Right.
Speaking truth and common sense here. This
common law. You know,
and I'm sure that you can go in there all emotional and, boom, you took my kids, and man, I'm going to get you, and I'm putting you into prison. You know, you didn't go off on him. You just said, hey, you know, professional manner here, talking man to man, that, you know, there's some inconsistency with it in the law, and that we need to discuss this. We need some adjudication here.
Right. You know, I can't fix it anymore. You know, I can't go back and change it any more than you can. I don't like it any more than you do, but we can stop it from happening again. That we can do.
Which is part of what you put in your report there is, you know, repeating history. And, you know, do we really want to repeat history exactly as it's happened in history? No.
Yeah.
We're supposed to be a civilized society now that's come I don't know how many years now are we into this. I mean,
Right.
come on, we should be able to sit down, talk man to man, and be man about this, and let's deal with this in an appropriate manner.
Correct. And that's the only thing I've asked them to do. And so, you know, I gave them the problem, gave them the solution, you know, an explanation in law, and I've given them a never before seen solution that is also in law. Right. And, you know, in one of the things in my case, when it comes to the relief and remedy, because that's one of the first things the judges look at, they want to see, they're going to base a lot of their opinion of you based on what you ask them to do. What you ask for is your end game. And, you know, as far as my end game was concerned, it was, you know, look, the U.S. Code says kidnapping across state lines is a death penalty offense. You know it. I know it. I'm not asking for that. The Constitution says when you violate this clause, you can be subject to loss of citizenship and exile, according to the original 13th Amendment. And I'm not asking you for that either. Even though it exists in law, I got a better idea. And my better idea was we're going to put these actors in prison because that's what we do, okay, with bad actors.
Right.
And they can, if they want to get out of prison early, well, here's what you're going to get for good behavior. And I actually got the idea from watching Shawshank Redemption, believe it or not. Make them sit down and go over and absorb the crap that they have put people through. That's their punishment. They have to listen to it, right? They have to travel through that purgatory, and they have to listen to that. That's their punishment.
Purgatory.
Right. They have to go through, create the arguments, create the documents, and get these nonviolent offenders, basically the people who are in jail for not paying fines and fees, for as an example, who shouldn't be there to begin with, get them out of jail and clear their name. And the more times they do that, they can buy down points and get out of jail themselves. That's my solution to how we fix this problem. So in context of the preamble of establish justice and ensure domestic tranquility, well, let's see. You screwed this up, go unscrew it. Pretty much like what your dad told you when you were growing up, right?
Make amends. You have to admit that you've done something wrong.
Right.
And then you have to make amends. You have to right the wrong.
Correct.
Okay. And then you're supposed to repent. You're supposed to not do that again. You're supposed to, in this, acknowledging that you've done wrong.
Right.
And righting the wrong. You're supposed to learn your lesson when you're righting the wrong of, man, this sure takes an awful long time to fix this wrong. I really don't want to do that again. So that's where the repentance comes in. Man, I don't want to do that again. I don't have to go through that.
Yeah.
So punishment is supposed to fit the crime.
Correct.
Wrong. And,
right.
You know, some of our laws say, you know, like capital felony treason, you know, that's death. Title 18, Section 242, acting under color of law. And if it involves deprivations of rights and it involves kidnapping, you know, you could be put to death for that. That's just how serious the people are about depriving people of their rights, you know, acting outside of your moral duties and ethical obligations under the law.
Right.
That you're supposed to understand, that you took an oath or affirmation to support, uphold, to enforce it as it is written.
Right.
Or abide by, because that's what constitutions are for. We the people make constitutions, and we tell the public servants what they can and can't do.
Right.
So when they act outside of what we tell them that they can and can't do, not only is that an unjust enrichment, it's acting under color of law.
Right.
You know, if it involves kidnapping, you know, we're supposed to be able to put them to death. But in a civilized society, and that's the reason why I love what Chris Hallett has put in there, which we actually kind of discussed this. I didn't actually know what he'd had in there, but, you know, my personal religious background and stuff, I understand how this is supposed to work religiously, which is actually the ideology that this country was founded on, which is Christianity. So walk the line of purgatory, right the wrongs, make amends, suffer the consequences. And let's not do the death part. Let's see if they can learn their lesson and repent and not do this again.
Should I read that part we're talking about, Kirk?
Yes.
All right.
This is in his paperwork.
Wait, what's the number? Not the page number, but the number. Like.
Oh, this is from the indictment, Kirk. Or I'm dead.
Okay, yeah.
Oh, okay.
You can't have that up there.
Yeah, this is actually page 14, paragraph 3 of the indictment, under as far as for punitive punishments is concerned. I just want to pull up the section where I pulled the maxims of law. So basically what I've asked for, as for punitive punishments for the actors is concerned, my suggestion is for them to endure the same journey in purgatory to which I was unjustly forced to walk alone. That said, instead of loss of citizenship and exile or the death penalty, as written in the Constitution in the U.S. Code, the only fitting punishment that would be just under the law in a civilized society is for these actors to be forced to continue from inside the prison walls to free all of those individuals who were also unjustly convicted and from which they profited.
That's a nice maxim.
Here's the maxim of law that I've applied thus far. One who offends unwittingly must make good knowingly. Okay? And, in continuation, non-violent offenders first, obviously. But instead of money as payment, they receive a point of reduction of sentence. For every unjustly incarcerated person, including clearing their name, they free from jail and make whole again. And I've applied 2 maxims of law there. The first one being, let me get to that page in the book so I can translate for you. What necessity compels, it justifies. Okay. The necessity being we've got good people in jail who shouldn't be there. So that's the compelling factor. And the second maxim of law that I employed was, let me get to the page, into a page, and I need my, the second is
Crystal.
And the second maxim of law is equity wishes the plundered, the deceived, and the ruined, above all, to have restitution. That is a maxim of law. And I applied it right there. So when it comes to logic, the reasoning, the application of law and why, there it is. So all we got to do is let the judge say yes.
Legal maxims are like, they're solid principles.
Correct.
They just can't be broken.
Well, it's how the judges can apply the law. You want them to take an action on your behalf, then give them as much information as you possibly can in good faith. If we keep going back to that, and just be reasonable. Speak like a human being. Yes, your rights have been pissed all over. Guess what? You're not the only one. All of us they've been doing it to every one of us.
He's muted all of us?
Now see, what the heck? I mute him, and it's still going through.
Don't know, dude. Who, me?
Not you, Chris.
Ah, okay.
Yeah, I'm not sure why that is. Something's up on your end too, because wait, now you are Kirk.
Yeah,
when you first called in, you weren't you were somebody else. It's something to do with Zoom. Zoom's wacky.
Kirk was having an identity crisis.
I was being called Crystal.
She's better looking than you, bro.
Oh, I don't know about that. Depends on your point of view.
That was funny.
Oh, it's Auntie.
Hey, I'm unmuted. What's up, fellas?
Ante, what are you doing? Yes, I did get
I'm
your
taking
call
a break
earlier.
from typing up this monstrous timeline.
Man,
It goes back over 20 years.
Hey, we discussed this, dude. It's a necessary evil.
Oh, yeah. And that's what I'm saying. I just hope you understand how large this thing's going to be.
I'm the one who has to apply this son of a bitch, so believe me.
I was going to say, Chris is the one that brought this. I'm pretty sure he's aware of how big this is. Everybody stand back now. How big this thing is going to get.
Well, it was funny because I seen Kirk's post about something about with, when you buy 500 pages of paper and, getting ready for a case, I'm like, well, shit, that's just one filing of mine.
Right.
Well, that was my point. I was up buying a ream of paper, and I'm looking. I'm like, 500 pages? That's just not enough. I don't want to have to come back in a few days.
Well,
I buy it in cases. It's cheaper than, like, if you go to Sam's Club, they got this case of 5,000 that you get for like $30.
right. Well, here's one of the great things about doing this. If you do it the right way, keeping it simple, right?
Mm.
The actors in these cases, they want you to go in there and go all half crocked and, blow, everything out of proportion and run, spew and run on sentences and light things on fire like Chris Farley did in Tommy Boy, So, you got to do everything you can to not do that. So when I wrote my actual indictment, the actual verbiage, the actual page count, not including evidence and all of the other stuff, it's only like 20 pages. He can read that in 5 minutes.
Well,
You won't even have to get up and go pee after he's done with it. So
my thing is I have multiple cases I'm working on.
right.
I'm working with Health Freedom Idaho. I just kind of picked up another case here. I've got one that I'm working on that's going to go down Wednesday. I think Chuck's still watching. So Chuck Fordyce, he's a local friend of mine. I actually know him from way back in the day.
Sure.
So, I'm out here trying to help my brethren and my what I call my family, my local people.
Right.
I'm getting local. This is what I've been trying to reiterate to people is get local. We need to this is one reason why we're looking for people that are on more of a professional level, like Chris Hallett and myself, to do. We want to teach you what we know so that you can start going into court with these people.
Right.
Okay? I want you to get to
not just teach you how
to tell these guys, no, I don't think so. You're not doing this, and you're not going to sit here and tell me that seek permission from you to get a license to practice law when this isn't even a lawful agency under the consent of the governed.
Right. We
You
didn't provide consent for this.
Your bar association. Where's that listed as? What department head would that be under? Where can I find that? So what department? When you talk about getting a let's say driver's license, you have to go to the Department of Motor Vehicles. When you want to get a business license, you have to go to Secretary of State. You have to apply for a business license. You want to get practitioner's license, medical license, you have to go to school, but you still get your license from the state, the medical board. Okay, but that's under the Department of Health. So that's where you get that license. All these other licenses.
Well, they claim they get their license from the Supreme Court, and it's just like, well, that's not a business.
No, but see, that's not a
Crackerjack box.
Department head. That's not an agency that has the ability to issue licenses. The judicial branch doesn't have the power to issue licenses.
There it is right there. And here's the other thing that's interesting.
It's an executive branch.
Right. Here's the other thing that cracks me up about that. Talk about conflicting orders. 1 minute they're saying, like in the Sims v. Ahern's case, you can't license it. You can't attach a fine or you can't attach a fee to it, et cetera, et cetera, et cetera. But on the other hand, they're saying, but that's exactly what we did.
Mm-hmm.
No.
Shapiro versus Thompson, or is that Shuttleworth versus Birmingham?
Oh shit, I don't know. Probably both. God, my brain is fried after today, bro.
You know what? I think it was said that
in my head, semi-memorized. So one of my all-time favorites you asked us before was Miller versus U.S. The claim and exercise of a right cannot be converted into a crime.
Right.
So when I'm claiming the exercise of a right, don't even bother with trying to say that I'm committing some sort of crime, because I'm going to throw Miller versus U.S. at you every time.
Right. That's fine. That's in my report too, by the way. It's in the table of authorities. Yeah.
I did see Miranda in there. Miranda, and I saw one other one in there besides Marbury versus Madison. I think everybody knows that one.
Oh yeah.
Marbury versus Madison, US 137.
Yeah, the list of cases that I cited in this thing was long, and it's 2 pages. So I've read every one of those son of a bitches.
Yeah, in fact, most of the ones that I have actually went down to the law library, pulled it up on Westlaw, pulled it up, read it, saved it, got it, and it's in Kirk's Law Corner. I have a zip file, case files. A lot of the ones that we talk about right here are in that case, in that zip.
You know, it's funny that you bring this up. There's a case, actually, John Gentry turned me on to this case. It's called Mitchum versus Foster from 1972. It's a real good read. Yeah, it's a damn good read. If you want to go in and you want to get kind of the feel for, civil rights violations and all that stuff, and, what the Supreme Court was saying in the discussion, that's a great case to read. You can find that one under Google Scholar. And, it'll definitely help you put stuff into perspective a lot.
A really, really good case to read, Cohen's versus Virginia. I believe it's Virginia. It's the jurisdiction case. It's an old case, but it's, oh my gosh, this case is so amazing. How it breaks down jurisdiction by law. Like, okay, marital rights and parental rights come from the law of nature at the common law. Okay. The proper jurisdiction to hear those rights would be at the common law jurisdiction.
Right.
Which is cool, because that's what actually, and that's one that you might want to look at, because there's some really good stuff in there. Like what you put in your paperwork here is you're talking about at the common law.
Right.
Common law rights. These are common to all, common sense, self-evident. Declaration of Independence says these are self-evident.
Correct.
There's supposed to be common sense here that I have this right.
Yeah.
You can't trample on this right, period. Don't tread on me.
Right.
All right, let's go over this.
They never listen.
This prohibition on improper guidance documents, because this is the kicker that just came out. This is the one we're talking about, Jeff Sessions. We did a breaking news on this, because as soon as this came out, I'm like, oh man, we got to get this out there, because the rule of law, he's putting the smackdown on. Let's go. This is awesome. And again,
I read that, and I read that whole document. I read it a bunch of times, and as I'm reading it, I come up and ask myself, now what are common guidance documents that are used in court? And the child support computation worksheet is one of them.
Right. Well, let's go completely broad here. Guidance documents, because statutes, rules, regulations, ordinance, which I started out the show tonight with that. That's policy. That's guidance documents. Those are supposed to apply to the agents of the agency. They're not supposed to apply to the people. That's not law. We, the people, lay down and ordain and establish law, not agencies, not the legislative branch. We are the legislative branch. We can't delegate an authority that we do not possess ourselves first. And there's a legal maxim. What I cannot do in my person, I cannot do through the agency of another. Hello? So back to...
Yeah, like how police always say it goes against our policy to arrest the women when they violate a protection order. And I'm like, really? So you're arresting me left and right.
Right. That's sexism. So back to what I was saying there was Chris Hallett, when this part of this Jeff Sessions thing is actually stems from the executive order, March 23rd, 2017, by President Trump to do an audit on the executive branch. And, this is what's in the start of Chris's paperwork is, hey, you asked me for help from the people, because that's what the executive order says. Anybody and everybody out there, come on, let's go. Want your help here. And that's what Chris did. He took it literally. I'm all right. You asked, you got it. And so this right here is stemming from that executive order, which, not to try and really toot Chris's horn, but I think Chris's paperwork may have actually something to do with this right here, as well as what's happening down there in the Bundy trials, which now they're talking about not even calling the jury back because they're in such deep shit over there. FAHQ.
Well, I couldn't tell you about that. I'm not familiar with the Bundy situation.
Well, I mean, I'm just saying that it's happening. It's affecting the federal courts, and the states are coming next. This judge down there in Nevada is backpedaling like crazy. They've been busted with tampering with evidence, or actually absconded with the evidence. It's just gone. This Mac laptop with all this data on it from all these cameras that they put up around the Bundy Ranch prior to any of this happening, as they were surveillance cameras, which is totally unconstitutional. That just disappeared from evidence. It was in evidence. It was already admitted into evidence. It's been sitting in the evidence locker for I don't know how long. But when it came time to be called, bring that evidence forth. We want to see the videos. We want to play the videos for the jury. Oh, well, we don't have it anymore. It seems to be missing. Okay, you better go find it. Let's get that chain of custody out, because I don't know how many people understand and know how evidence is supposed to work, but when they get a warrant or when they seize any kind of evidence, they're supposed to put it in a little package, mark it as evidence, and it goes in an evidence locker. It goes into an evidence locker. And it's supposed to sit there until it's called upon to be brought forth to the court as evidence. Ain't nobody supposed to be playing with that. And anytime it comes out of evidence, there's a document there, the clerk, you have to sign that paperwork. It's saying, I'm checking this item out of evidence and bringing it to court or wherever, taking it to the lab. That's called a chain of custody of evidence. And then if you're taking it to the lab, then it goes from the lab back over there. All of that chain of custody has to be documented. So kind of curious what happened to that laptop with all that information on it.
Anything that jams them, they just get rid of, and that's just how they do it. And they're like, well, we don't know what you're talking about.
Right, but see, the thing was, it was already entered into evidence. It's been itemized. Where is it? It was already.
They made it
disappear a year and a half later.
Oh, does that mean the case is tainted? Poison fruit? Oh, there we go. Rules of evidence.
I'm just going to go with tampering with evidence to gain a conviction. You didn't straight tamper with it. You just you stole it from evidence.
Right.
Trying to hide your crime. To hide out. Right. Oh, I know.
Yeah.
I talk literal sometimes, so I forget to laugh sometimes. So that's what I love about you, is you help me. Sometimes I'm good about it. Sometimes I'm not.
Chris has a jolly old laugh.
Legal stuff here, it's like.
Well, hey, I can whine and bitch about it all day long, or I can just fix it. And I guess I'm to the point now. It's like, I'm to a whole new level of screw it. Let's just fix it.
Well, that's
basically that's how it was told to me too. It's like, write the indictment. That's what they want us to do. They want us to write an indictment. Okay, let's write one.
Well,
okay.
Let's go over this, because Jeff Sessions is like, hey, DOJ is going to start taking your complaints and we will investigate them. So let's go over this document here. This is the memorandum for all components from the Attorney General, Jeff Sessions. It's signed at the top. little signature there. The subject is prohibition on improper guidance documents. Statutes, codes, rules, regulations, policies. Those are all guidance documents. The Department of Justice has the duty to uphold the laws of the United States and to ensure the fair and impartial administration of justice. Imagine that. Therefore, when the department engages in regulatory activity, it should model the lawful exercise of regulatory power. That right there, when we were talking about how the judicial branch doesn't have that power to do that, because the judicial branch doesn't have the power to make law. Executive power. The executive power has the power to make their little policies and their rules, their guidance documents. That's an executive authority, regulatory power. In promulgating regulations, the department must abide by constitutional principles and follow the rules imposed by Congress and the president. Right. These principles and rules include the fundamental requirement that agencies regulate only within the authority delegated to them by Congress. Us, we the people. They also include the Administrative Procedure Act's requirement to use, in most cases, notice and comment rulemaking when purporting to create rights or obligations binding on members of the public or the agency. Okay, members of the public. Who are those members of the public? That's not us, we the people. Members of the public trust, those that we either elected an official. This is Article 6, Clause 3. Everybody from every branch is supposed to be bound by oath or affirmation. You're either an elected official or you're in a position of public trust. That's the only two positions of public servants we have. Public being the key word there. Public service. Okay? So that's what that word actually means in the terms of this letter. The public, not us, we the people. So that's their administrative policies. These are supposed to apply to them. Not only in notice and comment rulemaking generally required by law, but it has the benefit of availing agencies of more complete information about proposed rules effects than the agency could ascertain on his own, and therefore result in better decision making by regulators. Not every agency action is required to undergo notice and comment rulemaking. For example, agencies may use guidance and similar documents to educate regulated parties through plain language restatements of existing legal requirements, or provide non-binding advice on technical issues through examples of practices to guide the application or interpretation of statutes and regulations. The guidance may not be used as a substitute for rulemaking and may not be used to impose new requirements or in entities, I can't quite see that one, outside the executive branch. Let me just open this up. Come on, wake up. There we go. So I can read it way better than that. All right, there we go. It has come to my attention that the department has in the past published guidance documents or similar instruments of future effect by other names, such as letters to regulated entities, that effectively bind private parties without undergoing the rulemaking process. That's us, private parties, private people. The department will no longer engage in this practice. Effective immediately. Department components may not issue guidance documents that purport to create rights or obligations binding on persons or entities outside the executive branch, including state, local, and tribal governments. Okay? To avoid circumventing the rulemaking process, department components should adhere to the following principles when issuing guidance documents. Okay, these are the top bullet points here. This is what's been laid down right here. Guidance documents should identify themselves as guidance, disclaim any force or effect of law, and avoid language suggesting that the public has obligations that go beyond those set forth in the applicable statutes or legislative rules. Guidance documents should clearly state that they are not final agency actions, have no legal binding effect on persons or entities outside the federal government, and may be rescinded or modified in the department's complete discretion. Of course, we can rescind that if it's a guidance document. If it's not within the law, well, of course we can say, nope, yeah, I don't think so. Guidance documents, number 3. Guidance documents should not be used for the purpose of coercing persons or entities outside the federal government into taking any action or refraining from taking any action beyond what is required by the terms of the applicable statute or regulation. Guidance documents should not use mandatory language such as shall, must, required, or requirement to direct parties outside the federal government to take or refrain from taking action, except when restating, with citations to statutes, regulations, or binding judicial precedent, clear mandates contained in a statute or regulation. In all cases, guidance documents should clearly identify the underlying law that they are explaining. To the extent guidance documents set out voluntary standards, e.g. recommended practices, they should clearly state that compliance with those standards is voluntary and that non-compliance will not in itself result in any enforcement action. So those right there are basically saying your guidance documents are nothing but guidance. That's it. We don't have to abide by them, and they're supposed to apply to them. They're not supposed to apply to anyone outside of this agency, outside of the federal government. And back to that one where it talks about the states, okay? The department will no longer engage in this practice. Effective immediately, department components may not issue guidance documents that purport to create rights or obligations binding on persons in and outside the executive branch, including state, local, and tribal governments. That includes the states, okay? So yes, this does apply to the states because we're talking about the executive branch. And in our form of government, we have 3 branches of government, and that's all laid down, ordained, and established through the Constitution of the United States of America. That's our form of government, guaranteed, Article 4, Section 4, Republican form of government. We are a constitutional republic, not a democracy. We don't get to put these rights to a vote. Okay, we own these, not government. Government doesn't give these rights to us. We instituted government for the protection of these rights. So all components shall implement these principles immediately with respect to all future guidance documents in consultation with the Office of Legal Policy. Components should also implement these principles consistent with policies issued by the Office of Management and Budget, including the final bulletin for agency good guidance practices, 72 Federal Regulation 3432. That was January 25th of 2007. So, man, Attorney General Jeff Sessions diggins there, huh? Furthermore, I direct the Associate Attorney General as chair of the department's Regulatory Reform Task Force to work with components to identify existing guidance documents that should be repealed, replaced, or modified in light of these principles. For purposes of this memorandum, guidance documents include any department statements of general applicability and future effect, whether styled as guidance or otherwise, that are designed to advise parties outside the federal executive branch about legal rights and obligations falling within the department's regulatory and enforcement authority. This memorandum does not apply to adjudicatory actions that do not have the aim or effect of binding anyone beyond the parties involved. And it does not address documents informing the public of the department's enforcement priorities or factors of the department considers in exercising its prosecutorial discretion, nor does it address internal directives, memoranda, or training materials for department personnel directing them on how to carry out their duties, positions taken by the department in litigation, or advice provided by the Attorney General or the Office of Legal Counsel. This memorandum is an internal Department of Justice policy directed at department components and employees. As such, it is not intended to, does not, and may not be relied upon to create any rights, substantive or procedural, enforceable at law by any part in any manner, civil or criminal. Well, you might have that in there, but you're the Attorney General, and you just lay down the rule of law.
Well, and what basically what he did
doesn't create any rights.
Exactly. So what it does is it limits government. Why?
Right.
Because, like the Supreme Court says, in a limited government, right? He just did exactly what he was supposed to do: limit the government, right?
Yep.
So, ironically,
all right. So we are.
But it doesn't matter if they don't listen. That's the whole point.
Well, this is okay. So this is what we were kind of supposed to get to tonight, was how to do this. And we're going to actually continue this to Wednesday. So what we're trying to do is tie all of these things together and show you how to use this. Again, I don't care what the first judge says. I don't care what anybody says. This is the rule of law. And we, the people, have the right to speak that law. And you have a duty and obligation. I don't care what position of agent you want to claim that you are, those two positions of employment to govern the people, you know, because we have to give consent to you to govern that way, and we don't consent to that way. This is how we consent, and we allowed you to do. You want to act outside of that? Well, we have a remedy now. So this is what we need to educate everyone on, and how to tie this together to your case, because this is going to be applied to any case. Doesn't matter what case you're in, this applies to it. The rule of law applies every time. So whatever case you're in, this is what we're going to try and teach you, is how to tie this all together. And like I said, we're going to continue over to Wednesday night. Of course, it's still the call-in show, but this is what makes this perfect, is we teach this stuff on Monday, and on Wednesday you come and ask questions about it. So,
well, another great thing is, you know, when you get all these things organized in one case, like for me, you know, I got a couple cases going on in different styles of courts. Once you get these exhibits all organized, then you just insert them in every single court. And, you know, it forces the court, whether it's civil, whether it's criminal, it forces the court and puts people on notice, like, hey, this is the law. You got to show me why you're transgressing it, or I'm going to prosecute you. And you just leave it as that. But when you enter it in, like me, I've entered it in a couple cases of mine. It's letting them know that I am aware this is what it is. And it lets them know that I won't tolerate if they try to go beyond that and use guidance documents or other things as law when it is not.
Right. Which is what we're trying to get at. So, Crystal, did you have anything? Are you even? You probably have yourself muted over there.
Oh, hello. How are you guys tonight?
Hello, my furry little rabbit.
Kirks are for kids after all, right?
You know what the bear said to the rabbit, right?
Right? Right. Sorry. Yeah. So anyways, I've kind of been listening off and on. Sorry, I've been at the library doing a billion things. When you were saying, you mentioned earlier in one of your comments that Jeff Sessions has stated that he wants to start taking complaints / whatever for the executive branch. How are you saying to do that?
Well, this is the thing, going back to exactly what I told Crystal back in January of 2017, Department of Justice. Okay, I haven't actually been back on there to see if they brought it back up to do online, but you can
right.
still download the PDF, the DOJ complaint form.
Right.
Crystal actually went and did this, and I'll go ahead and let you explain your process of what you went through, because you went through it. You actually listened.
And I got lucky. Yes, I did. But I actually did the online form, which was actually really easy to do it. It was basically just go online, find your grievance, what department you were having issues with. Mine was obviously the Department of Health and Human Services. Send them a letter, send them this online form, filled out what your grievance was, blah, 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 blah. And about less than a week later, I got a letter from the DOJ saying, hey, it's from a mail clerk, but whatever, they got it, saying we're not going to take any action against the agency that you are saying, which basically gives you the green light to go after that agency on your own.
Right.
And that is actually kind of a very, it sounds crazy. It sounds like a denial, but it's not. It's actually the letter you need to give you the green light in order to prosecute a department or agency under the specific department you're having in order to go to federal court with it.
Right. So
it's actually a very key part of your legislation, of your litigation.
Right. So what Crystal's actually talking about here is going after the agency itself. You don't need to seek permission from the DOJ to sue an individual under Title 42, Section 1983, 85, and 86. But to go after an agency, that's a little bit different. And so part of what the answer was to her, and I've heard it from a couple of other people now, is that they just are not receiving enough complaints to start an investigation. So with what Jeff Sessions just said, he's like, look, we're instructing the DOJ to take complaints and we will investigate them. So there's a catch-22 here. You need to start making the complaints in order to raise the flag for them to start the investigations.
Right. So literally you have to kind of resubmit what you've already submitted. Yes,
right.
But it's a new day.
And this is where I go back to, this is a new era, folks. The rule of law is being smacked down hard. And that's from the top. Now, we need to do our job from down here. And that's right. What I and Crystal and Ante and Brian Van Aken, there's several of us out here, grinding the gears, a bunch of gearheads out here trying to pump out the paperwork and start making some arguments.
I resemble that remark.
Right? That's why I went.
Well, mind you, I'm already in the federal court, and I've been sitting in recess for 3 months.
Well, yes, they're all stumbling over themselves because of Chris's work. They're like, this affects me and my job. I better. Oh man, that's an emoluments violation. How do I get myself out of hot trouble now before it actually starts coming down? Because what do I do here? Yeah.
which is one of the reasons I'd like for Crystal to explain the Bivens complaint, because she just filled one out, and she's actually really good at this. So you should take notes when it comes to how to basically go after a specific agency, right? So I'd like to hear Crystal's interpretation of that.
Silly rabbit.
Oh my gosh, really? Silly rabbit, because she's kind of crazy.
Yeah.
Anyway, so Bivens complaint. So there's two different kinds of complaints when you're talking about a 1983. There is what you would consider and this is going to sound really weird. There's basically a prisoner's complaint, and there is a non-prisoner complaint. And a Bivens has to do with a federal agency or a state agency in regards to, sorry, I'm just walking in the door from work, in regards to somebody who possesses the color of law. So that is a big time difference between a regular 1983 and a Bivens. You know, and so a Bivens goes into, hey, do they have a color authority? Do they have this? Do they have that? You know, what is it that they hold? And if they have, if they uphold the color of law, which color of law would be an officer, an agent, somebody in authority. Or, sorry, my mind is a little spread out this morning. So it's a big time difference. So it's basically when somebody with an oath of office or oath of authority or oath of law has violated your rights is when you want to create a Bivens. And so that's where you get the difference between a regular non-prisoner complaint brief or complaint form and a prisoner. Doesn't mean you are imprisoned, as in you're in prison. It is just that's how the court signifies the difference between the color of authority or the color of law versus an agency like, you know, CPS or the state or an individual when they're looking at a complaint brief, a civil rights brief.
Right. And I'm going to interject something here real quick, Crystal. In differentiating between the prisoner and non-prisoner, just because you're not behind bars does not necessarily mean a non-prisoner applies to you. For example,
correct.
If you've been tried and convicted and found guilty of a contempt charge, okay, that is
right.
You can apply the prisoner documentation because you can definitively show, hey, look, they found me guilty of this contempt, and where's their evidence? Right?
Right.
What's your proof? Why did you do this? So that's, you know.
Or if you're tried as like a CPS offender, as an abuser in CPS's eyes, but yet you can prove it didn't happen, you would file a Bivens.
Correct.
Right. So what I was going to touch on there was the fact that, okay, when any of your rights have been arrested, okay, you've been deprived of any of your rights, even if it's been adjudicated and you know that it's wrong, that right has been arrested. So you're essentially incarcerated. Doesn't necessarily mean you have to be behind
bars. And if you don't even step foot into a jail.
Even if you don't step foot into a jail.
Right.
Yep. And that's the part of arrest. What arrest really means is to stop something. So if it's you've been placed under arrest to stop something, it's already been adjudicated, but you're not actually in jail, you're still under arrest. Your rights have been arrested from you. So arrest doesn't always mean taking you to jail. Okay? Arrest means you being prohibited from exercising a right of liberty. Most of the time it's liberty. But it can be life, liberty, pursuit of happiness, property, any of those plethora of rights that are out there. If you're being deprived, especially after it's been adjudicated, you're still under arrest from that final judgment, that order.
Correct.
Yeah. So just so people understand that there are two different kinds. So when you're looking up on federal court, the federal court side, and you're looking for a 1983, a 42 subsection 1983, and you say prisoner and then see non-prisoner, like I said, if you have been charged with any crime at all, or you have been prohibited, like an officer, let's say an officer pulls you over and detains you for 90 minutes. He didn't have probable cause to pull you over, but he detained you for 90 minutes for whatever the reason. Okay, that you would then go under the prisoner one, even though they didn't issue you a ticket. It's the fact that somebody of the color of law held you in for a detention or whatever for a period of time.
Yeah,
So,
I actually have a treatise on arrest and false imprisonment that specifically talk about this kind of stuff. Even just the officer telling you to do something
yep.
Without lawful authority, like you go sit over there on the curb, that is not a lawful command.
No.
Okay? The deprivation of your right of liberty. Are you free to go? They call that detain. Well, I'm just detaining you. I'm just detaining you. No, that is an arrest. You're being deprived of your right. And I'll tell you right now, when an officer tells you to go sit over there on that curb without lawful authority, that's a $10,000 lawsuit just in that statement right there.
Right. And then the longer they keep you, it actually goes up from there by the minute.
Right.
Because a lawful detention is no more than 30 minutes. Any more than it's like 45 minutes, it's actually illegal. That's when you actually hop up to imprisonment, which is a totally different subject.
Well, see, and this is where I go back to actual law and the common law, because that's all void right there, because the common law avoids that. The common law says you cannot pull me over unless you have lawful authority.
Probable cause.
To make an arrest.
Probable cause.
Be a felony happening directly in front of you. Okay?
Right. As in speeding, a violation.
No, there's no such thing as violation. Okay. It has to be
impeding the speed limit.
No. Well, that's not an arrestable offense.
That's the difference between a citizen's arrest and a police officer. Right?
No.
There is no difference.
See, this is law. Okay. The law. No man is above the law, and statutes, codes, rules, and regulations and policies are not law. Okay. The law says you cannot place a man under arrest except for a felony happening directly in front of you or a breach of the peace. That is the common law, the rule of law. There is no other law that can come in conflict with that. It is null and void from its inception, Marbury versus Madison, plain and simple. This is what we need to understand. Officers, police officers, do not have the authority to even exist in law, which I went over that last week, reading the Idaho Constitution and reading from another document. We're not supposed to have a police force, period. There is no authority to create a police force. We're supposed to have military. Everybody else that is in the unorganized militia is the police force. We are self-governed.
Right, with the exception of the sheriff.
Right. See, the sheriff is the guy that goes, you know what, let's form a posse and we'll go get the bad guy. So the sheriff goes around and grabs 5 guys and says, grab your guns, let's go get this guy. Okay? Wanted, dead or alive. Preferably alive so we can bring him to justice. But if he refuses, shoot his ass and drag his body here. Okay? That's law. That's the common law. That's how it's supposed to be. That is what the law actually says. Okay? And what the law actually says is we only delegated the authority for military purposes, for foreign invasion. 1, at the federal level. 2, at the state level. Who runs that? Well, let's see. We, the people, through the legislative branch, we gave the proper delegation of authority to create the organized militia. Now, if you read the Second Amendment, that's what it says. Militia being necessary for the security and freedom of the state, right? Okay, that's what we're talking about. But the right of the people to keep and bear arms shall not be infringed. So it's necessary for everyone to be armed so that we can get pulled into the militia, the organized militia, when called into service, but so that we can also act on an instance to defend ourselves, our life, our liberty, and our pursuit of happiness at any time, because that's an act of tyranny. If you're trespassing on me, that's unlawful. You can't do that. That's the law of the land. So another thing to think about, and to put this in a better perspective, when, okay, let's say an ambulance is behind you and he's got his emergency lights on and you're supposed to pull over to get out of the way, right? Does the ambulance stop behind you and say, hey, you were going a little fast there, we're going to give you a ticket? How about the fire truck? Fire truck turning his emergency lights on, and you're supposed to pull over and get out of the way, but the fire truck pulls up behind you and says, hey, you're going a little fast there, pulling you over, going to give you a ticket. That's the same thing with this police car with its emergency lights, okay? You can't make an arrest unless it's a felony happening directly in front of you or a breach of the peace. And again, I've gone over the breach of the peace. The breach of the peace isn't necessarily disturbing the peace, which it kind of is, but it isn't. But again, you have to understand arrest. And again, this has to be happening directly in front of the officer or you, whoever's the arresting party. You're stopping the fight, because that's what breach of the peace is two people arguing loud enough to disturb other people, the peace of the other people around, okay? And that needs to stop. So that's making the arrest. That doesn't mean take them to jail, okay? That's only to stop the action that's happening. So in the felony sense, you know, we're talking about rape and murder and that kind of stuff. That's the type of felonies that are arrestable offenses. There's no such thing as an arrestable offense that's an infraction, because that falls under bills of attainder. And then there's no authority to arrest for misdemeanors, because that falls under bills of attainder and bills of pains and penalty. Article 1, Section 9, Article 1, Section 10 both prohibit bills of attainder, both to the federal and the state level. So again, that's law. That's what the law says. That's how it's written. So on that note, anything else anybody like to add? Say?
Oh, I think we're about ready to get ready to move on to Wednesday's segment and start teaching people how to apply this stuff, because that's where it gets real tricky, is how to apply it.
Right. So we want to thank you all for tuning in tonight. Like, share, follow, all that good stuff for Kirks Law Corner, the March S. If you want to get in with the Amber and Steven group, that's out there. Kirks Law Corner is a group as well. We have documents and that kind of stuff in there. So some of the stuff that we talk about is in there in the files sections of the group. So thank you, Ted, for promoting this, doing all your fancy tech stuff over there. I really appreciate what you do for us. And Chris, I love you, brother. I love you all. Crystal, Ante, thank you for coming on tonight a little bit there.
Got a little sneak peek. Wednesday night, we have a special guest coming on. New guy, so.
And it's not me.
Yes, and it is not Crystal. So get ready for Wednesday night. I got a nice little surprise for you guys. So
awesome.
Thank you, guys.
All right.
Great show.
Thank you, ladies and gentlemen.
Love you guys. We'll be talking to you.
Thanks,
much
and
love.
have a good night, y'all.
There's
Okay.
hope, folks. Let's make America great again.
That's it.
From our side.
Our job.
Start performing those duties as American.